mention now that we need to finish today preferably by 4 o'clock, and at the very latest by 4:10. So if you could collectively bear that in mind. We are making good progress. Right, Mr. Jackson.
Thank you, my lord. So I said just before the short adjournment, I'd come on to diplomatic immunity.
Yes.
I suspect it's apparent from my primary submissions is that our main cases it simply doesn't arise. Because state immunity and diplomatic immunity are not the same.
Yes.
I won't repeat all the reasons I've already mentioned, but what I will do, and touching I hope as briefly as I can, is say that logically, if diplomatic immunity were to apply, whether it be in this case or indeed any other, one would be looking for the same thing as one is looking for state immunity, namely a rule of customary international law, which says the immunity applies in this scenario functionally for these reasons. It will be apparent from that being my submission that I don't intend to repeat what I've already said about why there is no such rule, because we say there's not. And the reason why there's not is the same in both cases, that there is simply not the widespread representative of a consistent practice of state on the point in question. And for reference, that's 31 in Bencarbish, but we've been to it a number of times already.
Yes.
Our submission is that, as with state immunity, the response case simply doesn't come anywhere close to that standard. As I forestalled in my submissions earlier, and I hope not to be too repetitive, in any other case, a submission that I was making to this court that one side of the other's argument is novel would be an interesting jury point that probably wouldn't help this court very much. The reason why I say in this case it does matter is because if you are looking for widespread and consistent practice, a novel, or at least relatively novel argument, for which we say there is almost no support, is fatal to that finding of a widespread, well-adopted practice of states. And I also, to some extent, adopt what Mrs. Justice Ellenbogen said below in respect of, first of all, the Diplomatic Privileges Act and the Vienna Convention, which is incorporated thereby, namely that the interpretation urged upon that tribunal, and I believe this court as well, does violence to the language of the Vienna Convention. That is for a number of reasons, but essentially when one looks at the Vienna Convention, particularly Article 31, which for reference, if it's needed, can be found on the authorities bundle, page 11. I'm not prepared to take the court to it again because it's one which we've been over a few times.
Can you just give us the paragraph reference from the EAT judgment? No need to look at that either, but just so that we can find it.
And so that is paragraphs 18 to 30, primarily paragraph 18.
Of the EAT?
Of the EAT, my lord, yes, and that is in the core bundle from pages 94 to 99. I will add further that, if I may, in respect of the reliance placed on Kramer et al., that is an approach I say was deprecated by Lord Sumption in Bencarbish. That I will take you to, if I may. The authorities bundle at page 213. I'm not, of course, trying to restrict the court's reading in, because paragraph 73 is quite a long one, but the portion I say is relevant to this argument. In F and H on page 213, where his lordship says it's not for this court to review the domestic case law of other jurisdictions cited, least of all when they're based on the categorisation of particular facts. And goes on to express a view about this, the same Gupta case which is being talked about. I accept my defence not relying on it now, but I'm taking to this for a different purpose, which is that Lord Assumption seems to suggest one isn't simply to conduct a case-by-case analysis of what other countries do and look at their domestic law, but rather be guided as what's been said already, a widespread practice, rather than simply looking for one or two examples. That's why I say the example given in this case, as well as being novel, doesn't help, because it doesn't comply with that guidance given by Lord Assumption. That is why, as I say, the reference to Article 31, I say Mrs. Justice Ellenbogen was correct to refer to doing violence to the wording. So if one looks at Article 31, the wording is he, obviously in the old-fashioned sense, not they or it. It's not referred to a state, it's referring to a person. And if one looks at the rest of the Vienna Convention, other than the portions that deal with immunity being the property of the state in the sense that an individual cannot themselves waive it, it is, as Lord Assumption says in Ben Carbuche, functionally directed at the protection of diplomats, not at the protection of states. The obvious reason for that, as one can see, is that the idea is that you don't have diplomats who are themselves subject to claims in a way which is designed, or indeed perhaps the purpose is to bully or harass them because of their diplomatic position. The functional purpose is to give them protection, not to give their sending state protection. That is why I say the two versions of immunity have developed separately and do not have the overlap which is urged upon this court by the Kingdom of Spain.
Yes.
Could I also, just whilst dealing with this point, go back a little to paragraph 59? It was a paragraph to which is taken by my learned friend, and it's at page 207. Apologies for going back to the United Nations Convention, but I'll do so only briefly. The court was taken to the portion between C and E, beginning, so it's both propositions received substantial support, and there was, I won't repeat the discussion that happened with the travaux preparatoires and also the final version of the convention. What I would invite the court to read on, though, please, is to the section beginning at E, the sentence on the right-hand side of the page saying there is, however, only limited international consensus on where the boundaries lie. The reason I refer on to that point is that I say it simply makes my case again. Regrettably, as with most of these cases, there is no clear, bright line. But if one is looking for one, the consensus on these particular points which arise from the United Nations Convention, I say, are unlikely to be helpful for the reasons that Lord Assumption has given, namely that there is limited international consensus on how they apply and in which circumstances. I don't propose to take the court to Kramer et al. The court has it and has my submissions on it,
Yes.
unless there are any particular points I can assist with on the case. I don't think I can, forgive me, do any better than what I've already said, which is that we say Mrs. Justice Ellenbogen was right in this respect for the reasons which she gave. And before I conclude on that matter, there was one practical example that my learned friend gave, which I say illustrates this point quite well. That relates to a Ukrainian working in the Russian embassy, and how that might apply in these circumstances, because one has different geopolitical considerations. And to an extent, I accept my learned friend is right, but I say, as with everything, context is key. What is or is not a state function, which is close to the acts of state enough to be immune, is going to be different from two countries who are actively at war with one another than it is between two countries who are, for the better or worse, having friendly relations.
I don't think the Ukrainian working in the Russian embassy is a very good example. I mean, he or she would disappear within 5 minutes, but
the same would be true in any other example, my lord.
Yeah.
The context of the relationship between those two nations is important, because one can easily see two nations who are at least unfriendly, they are not actively engaged in warfare, may have different state interests than those who are friendly and have trading relationships and have no significant dispute between them.
Well, there's a spectrum, isn't there, of international
Indeed.
relations between countries that are exceptionally close and countries that are at war.
Hence why I say the context is key, because I'm not suggesting for a moment that Spain and the United Kingdom have no distinctions between them, because of course Gibraltar is one of them.
They have issues over.
Yes.
Yeah. Right.
But there is a functional difference between cases, I say, at that end of the spectrum and the other end of the spectrum that my lord identifies. And it is one of the reasons, unfortunately, why one can't say there is this bright line rule that you fall on one side or the other. Because when one considers everything, unfortunately, one can't say in all circumstances a particular thing must be right or must be wrong, save for example, if one's dealing directly with diplomatic communiques or intelligence matters. And those are specific matters which are referred to both by Lord Sumption and indeed in the other case law as well.
I appreciate that you say there are no bright line rules, but it can't surely depend on the degree of friendliness between two states. And I've always understood, as far as I know anything about international law, that you put to one side countries, the extreme example with which His Majesty is at war, I don't think there are any at the moment, or countries with which the UK has no diplomatic relations. That may all be special. But if you're looking at the nature and extent of state immunity of an embassy, say, can't really depend on whether the embassy is from a agreeable rule of law in latter days EU country on the one hand, or a country with which we have diplomatic relations but sort of only just and not much in common.
No,
State immunity can't depend on that.
I accept that, my lord, so far as it goes. What I say is that it must be part of the picture. One can't simply say an active state is an active state is an active state without any review of what the context in those acts are. There must be some exceptions, as I have already accepted. So if you're dealing with intelligence matters, for example, even with friendly states, so it is understood. I can't say I have any personal experience. Intelligence happens one way or another, but that's not to say, because there are some examples which definitely must be acts of state. At the other end of the scale, there are others that definitely must be acts of administration. As my Lord Justice Begg says, there must be a spectrum, and I say it's part of the picture.
Shifting spectrum too.
Shifting spectrum, my Lord, yes.
All right. Are you done on diplomatic immunity?
I believe I'm, Lord. Let's make sure that something else of substance I wanted to say. The only point to conclude with before I move on, the point is made about the impingement of the personal immunity of Senor Gonzalez. That's a matter which is dealt with in the Employment Appeals Tribunal, and I won't repeat it, but that immunity, if he remains a diplomat, is still there. If the state of Spain is impleaded in the case, the Employment Tribunal, provided that he remains in a diplomatic position in this country, has no jurisdiction to summons him to give evidence. It has no jurisdiction to order him to give evidence of any sort, disclosure or otherwise. And if he's not in Great Britain, the tribunal has no jurisdiction anyway because of the rules in the Employment Tribunals Act. So that there is a real sense in which diplomatic immunity is not affected by any decision this court makes on state immunity. And that, I think, unless I can be of further assistance, deals with the appeal. I should deal with what I think I've categorised as RN1 in our respondent's notice. In our skeleton, that comes, forgive me, at page 69 and through to 6, forgive me, of the core bundle. I have already at some length taken the court to Employment Judge Siegel's reasons that he gave between 18 and 65. My submissions on this point on the cross appeal, if it is indeed a cross appeal, it might be, these are simply other reasons for supporting the EAT's order. The reason I say is it's not clear what paragraph 2 of the order is actually doing, referring to allowing an appeal in principle, but then still dismissing the appeal. So hence why I've characterised it in the way I have. Simply relied on those submissions I've already made. And the order from the EAT is at 78 and 79 in the core bundle for reference. I will to some extent be repeating what I've said earlier if I go much further. Simply say I'm happy to stick with what we have said in our skeleton unless any other particular points on which either myself or my learned friend can assist.
So, thank you, Mr.
In which case I'll sit down at that point and hand over if I may.
Yes. Yes, Miss Payne.
Good afternoon, my lords, my lady. Well, I hope that now that Mr. Jackson has done much of the heavy lifting, my submissions will be short, and they will follow, I hope, the conclusions that Mr. Jackson has urged this court to make on the nature of Section 42A of the State Immunity Act, and whether it is justified by rule of customary international law. I intend to address the court on the declaration, and when I conclude my submissions, I will hand over to Mr. Jackson to conclude the claimant's case. My lord and my lady, the claimant's request for the declaration is set out in brief in her skeleton argument at paragraphs 57 to 60. Forgive me, I ought to give you the core bundle reference.
75.
Thank you. In short, the claimant invites the court to make a declaration that Section 42A of the State Immunity Act 1978 is incompatible with Article 6 of the Convention, both on its own and in conjunction with Article 14, and also as a secondary point to find that it is incompatible with Article 1 of Protocol 1, also on its own and in conjunction with Article 14. My lords, my lady, this court's power to award a declaration is of course found at Section 4 of the Human Rights Act, which is page 37 of the authorities bundle. And a declaration may be awarded where the court is satisfied, A, that the provision is incompatible with convention right, B, that the primary legislation concerned prevents the removal of that incompatibility. And if those criteria are satisfied, it is at the court's discretion whether to make that declaration. So three things for the court to decide: incompatibility, no convention compliant construction is possible, and whether to exercise its discretion. My lords, on the first point of incompatibility, if you are with us on the substantive appeal, namely that section 42A presents a restriction of the right to access a court to have a dispute determined, and that restriction cannot be justified by a rule of customary international law, then it follows that it must be a breach of Article 6 of the Convention. And indeed, that was the analysis followed by the Supreme Court in Benkar-Bush, paragraph 20 of that judgment, which Mr. Jackson has already taken you to, so I won't take you there again, but it's at page 186 of the authorities Bible. And what Lord Sumption went on to say further on in that judgment, at the bottom of paragraph 34, which is at page 194 of the authorities Bible, at E, anything that goes further, any restriction that goes further than international law requires, is necessarily disproportionate. And I hope that Mr. Jackson has persuaded you that there is no such rule of customary international law that would justify such a restriction. Now, my lords, my lady, the Supreme Court, of course, in Benkar-Bush found that section 42B of the State Immunity Act, which denied the claimants who were non-UK national embassy staff access to a court, was not justified by any rule of international law. And furthermore, Parliament has acted to cure that incompatibility with the 2023 amendment regulations, which can be found at pages 26 to 30 of the authorities bundle. I don't intend to take the court there, but simply for noting. Now, of course, section 42A is different from section 42B. And of course, this court is not bound by Benkar-Bush to find that because B was incompatible, thus A must also be incompatible. But of course, it is the respondent in this case, the Kingdom of Spain, who has sought to justify the restriction of Article 6 that subsection A prevents, to prove the rule of customary international law that will justify it. And he has not shown that there is such a law. And indeed, while this court has heard an awful lot on this point today, and has been taken to many extracts of Benkar-Bush, and I wouldn't want to tread old ground, but I would like to take the court to paragraph 66 of Benkar-Bush, which is page 209 in the authorities bundle. Which is really the high point of the Benkar-Bush decision. And the extract that I shall read is at page 209G. Lord Sumption simply says, the considerable body of comparative law material before us suggests that unless constrained by a statutory rule, the general practice of states is to apply the classic distinction between acts iure imperii and acts iure gestionis, irrespective of the nationality or residence of the claimant. My lords, the Supreme Court in Benkarbouche not only issued a declaration in respect of section 42A, but it did the same in respect of section 16(1)(a) of the State Immunity Act, which, as it then was, prevented employment claims by members of a diplomatic mission. And it's the Supreme Court's comments about section 16, found at paragraph 69 of its judgment, which is at page 210 of the authorities bundle. We say our comments that apply with equal force to section 4(2)(a). And in particular, the first few lines of that paragraph, which, if I may paraphrase it, requires that any rule that bars all claims by an employee of diplomatic mission, irrespective of whether the employments or acts complained of were sovereign, could not be justified by any general principle of immunity under the restrictive doctrine. Indeed, it could only be justified if there were some special rule that justified the absolute bar. And at paragraph 75 to 76 of Benkarbouche, which I do not intend to take the court to, it's enough for the sake of the court to note it, the Supreme Court found that there was no such special rule. Thus, 16(1)(a) was also incompatible. So, my lord and my lady, I don't intend to say any more on the first of the statutory criteria, and the claimant hopes that we have satisfied you that section 42A is indeed incompatible with the convention right, namely Article 6. I should note that my submissions on Articles 14 and Article 1 of the first protocol will follow towards the end of my submissions. So the second criterion set out by section 4 is that no convention compliant construction of subsection A is possible. We say that must be true of section 42A. Section 3 of the Human Rights Act, which is at page 36 of the authorities bundle, requires that legislation must be read compatibly with convention rights insofar as it is possible. But it's clear that that concept of possibility has limits. And indeed, those parameters were defined so memorably by Lord Nichols in the case of Gaidan and Godin Mendoza, paragraphs 30 to 33, which are found at pages 92 to 93 of the authorities bundle. Excuse me. And in particular, if I take you to paragraph 33, which is on page 93, between B and C. Now, while the interpretive obligation under section 3 is of an unusual and far-reaching character, its scope, of course, is not limitless. And the meaning imported by application of section 3 must be compatible with the underlying thrust of the legislation being construed. And indeed, in Lord Rogers' memorable phrase, it must go with the grain of the legislation. Well, the plain English of section 42A, which if I could take you to, my lord and my lady, at page 21 of the authorities bundle. what Section 42A provides is that a state is immune in employment claims in the UK if the claimant is a national of the state concerned. Now, what would be required for the convention compliance interpretation is for this section to be read down to say that immunity does not apply where the claimant is a national of the sending state. And in brief, that would be to say that black is white and white is black and would amount to impermissible judicial legislation. So, therefore, the claimant submits that both of the statutory criteria for the declaration are met. And therefore, it falls to this court's discretion as to whether to issue the declaration. And indeed, the claimant urges the court to do the very same.
Could it not be said it's all past history now?
I'm sorry?
Could it not be said that in a way it's all past history?
Because Parliament has already amended
Yes.
subsection B. Well, my lord, I think that the claimant's specific circumstances would still be precluded in section 4 as currently formulated, because subsection A still has not been, that was not touched by the amendment regulation, so that still reads as it was. And arguably leads to a rather displeasing discordance in the law, which is a point that I will come to. The recent case of Secretary of State for Business and Trade and Mercer, paragraph 118 of that judgment.
This is Lady Simba.
It is, yes, my lord. And this is page 284 of the authorities manual. And her ladyship, at paragraph 118, cites the earlier case of the Ministry of Justice, which said, and I'll read this to the court, it would of course be unusual for a court to hold that a statutory provision conventionally construed infringed a convention right and could not be compatibly construed with it, and yet refuse to make the declaration under section 4. Now, the claimant's submission is that the implication of such a dicta is that the declaration is the norm and the refusal to issue a declaration is the exception. At the subsequent paragraph in Mercer, her ladyship noted that the circumstances in which a court may exercise its discretion to decline to issue a declaration engage no particular considerations favouring one course over the other. But in this instance, the claimant can certainly identify no good reason to displace the general rule that it is usual to award a declaration. And in any event, the claimant understands that it is not the respondent's case that if a breach of Article 6 were to be found, that to issue a declaration would be inappropriate. And nor has the Secretary of State seen fit to intervene. And so the claimant says that it would be entirely appropriate for this court to follow suit and to issue a declaration in respect of section 42A. In particular, there is a single specific provision which gives rise to the incompatibility. It cannot be said that there is a lacuna in the law, nor could it be said that to issue the declaration would create an inconsistency in the law. And indeed, as I alluded to earlier, it indeed may assist in curing some of the inconsistencies in the law. As section 4.2, now amended by the 2023 regulations, qualifies the concept of immunity for individuals who are not nationals of the UK, but does not do the same if the individual is a national of the sending state. And therefore we say that the declaration would be entirely inappropriate, not least in circumstances where the Supreme Court has already made a declaration for subsection B and section 16(1)(a) of the same Act, and Parliament has acted to resolve that incompatibility. My lords and my lady, the respondent, my learned friend, Mr. Davies, in his supplemental skeleton argument, did raise various contentions when resisting this declaration, that the nationality exception to state immunity may be a rule of customary international law. I had been intending to take you to the various extracts of Ben Carbuche which we say show no such thing, but I think that this court has seen quite enough, and I wouldn't want to repeat submissions already made by Mr. Jackson. That then concludes my submission on the declaration in respect of Article 6. If I may turn briefly to Articles 14 and Article 1 of the first protocol. Dealing first with Article 14, which can be found at page 41 of the authority funding.
Is nationality a protected characteristic?
It's, my lady, Article 14 requires that the enjoyment of rights and freedoms set forth in this convention should be secured without discrimination on any ground, such as materially national or social origin. So that's the third line, third line down of that article. So we say that Section 42A falls squarely within the ambit of Article 14. Now, it's worth noting that the Supreme Court in Ben Carbuche didn't decide the Article 14 point. Having already found an incompatibility with Article 6, it went no further. But my lord and my lady, if you're with us on the Article 6 point, then a violation of Article 14, we say, inexorably follows. The plain English, Section 42A, namely that a state is immune in employment proceedings if the individual is a national of the state concerned, clearly restricts access to a court, depending on one's nationality. And we therefore say that it plainly follows that if Article 6 is violated, it is violated also in conjunction with Article 14.
Because Article 6 is clean cut, because not only do we have the assumption for it that it's such a fundamental right that impinging on somebody's access to the court is pretty fundamental. Article 14 is a bit more nuanced, isn't it? We then end up talking about whether there's a justification, whether it's proportionate, all of that, and that's really been argued out. It's difficult to see objectively how there could be a justification, but there might be. Somebody might want to raise it, and I'm not sure that we've got the material.
My lady, I agree that this hasn't been the focus of detailed submissions in this appeal. The claimant draws reassurance from the fact that neither the respondent has raised points, justification points, and again, nor has the Secretary of State sought to intervene. Of course, we have considered one possible justification for the differential treatment, which of course the rule of customary international law.
That brings it back into a circular argument.
It does. And actually, I do my learned friend Mr. Davies a disservice because I believe that he does raise a couple of points in his supplemental skeleton. If I can find the relevant paragraphs, forgive me. Yes, paragraph 15 of his supplemental skeleton, which is page 141 with the core funds all. Now, there appear to be some submissions here. Now, I think they're in respect of the primary points, the primary argument. But there is a reference to contractual advantages to the claimant's employment having contracted with the embassy on the basis that she was a Spanish national. But these are referred to only very fleetingly. Right to take a break and return, and also certain tax privileges. But no more arguments are raised than that. Now, if that is the extent of the respondent's submission, then we say that hardly suffices to justify the differential treatment, given the fundamental nature of the Article 6, which is breached. Unless I can assist any further on the Article 14 points, I'll proceed to my final submission, which, as a secondary point, we say that section 42A is also incompatible with Article 1 of the first protocol, which, my lord and my lady, if you'll permit me, I will refer to as A1P1.
Anyway, yes, very good abbreviation. Have you put in a skeleton on this, or you're obviously entitled to what Mr. Davis said in his supplementary?
It's referred to in passing in the claimant's skeleton argument at paragraph 57. Is that right? 59. Yeah, apologies. It's on paragraph 59, which is page 76 of the court funds. So the claimant deals with the points very briefly in the skeleton argument. And I intend to elaborate somewhat on why that submission is made. I'm sorry,
I was just wondering, I mean, it's pretty skeletal what you've said here. And I hope Mr. Davis is not going to be taken by surprise by anything this page at this point. Let's see, shall we?
I do hope so. I hope that he would have had some indication of where we would go by the authorities and the underlining that we have submitted.
Yes.
But perhaps Mr. Davis can address the court on whether we've sprung him a surprise. The text of A1P1 is found at page 42.
You put it in a footnote in your skeleton, don't you?
Well, that's right. Indeed, if that is easier,
Yes.
then you can stay exactly where you are. It effectively states that every person is entitled to the peaceful enjoyment of their possessions and should not be deprived of those, except in the public interest and subject to conditions provided for by law.
What's the possession money this time?
Well, what the claimant's submission is that the right to have her claim determined by a court
Shows an action.
with the consequent right to obtain a pecuniary remedy falls within the ambit of A1P1. We say A that it is analogous to a chosen action, which is well established amounts to a property right. But we also say that it is comparable to a welfare benefit, because much like a welfare benefit, which is a sum of money, contingent on judgment by an organ of the state that an applicant satisfies certain criteria, so it is that the right to have a claim determined by a court on the basis that the claimant satisfies, again, certain criteria or meets a specific legal test, with the prospect of a pecuniary remedy.
Is there case law that supports the submission that that comes under the definition of possession?
There is not case law that says, that makes that specific point, and I think we have to concede that this is a novel point that we are asking the court to make as a matter of principle, following the authorities, and in particular the authority that we rely on is the decision of this court in JT and First Tier Tribunal.
Lord Justice Leggett.
That's right, my lord. And in particular, there are two paragraphs that I'd like to take the court to, starting with paragraph 44, which is found at page 230 of the authorities bundle. And here at G, his lordship stated that the European court has interpreted the concept of possessions broadly. As well as tangible property, it has been held to include various intangible rights and legitimate expectations to payments or assets of various kinds. It then, in the subsequent paragraphs, his lordship goes on to consider the leading case, the leading European case of Steck and United Kingdom. And having thoroughly reviewed that authority, his lordship comes to the conclusion at paragraph 50, which is at page 232 of the bundle. And his lordship concludes that although the Steck case was concerned with welfare benefits, I can see no logical reason why the second step in the court's approach, which I'll come to, should be confined to cases involving such benefits. It seems to me to be an application of the general principle that where a state creates, under its domestic law, rights which fall up within the ambit of a convention article, it must do so in a non-discriminatory manner. And we therefore say...
A1P1 read together with Article 14, not A1P1 as a freestanding point.
That's right, my lady. And indeed the claimant's submission is that Section 42A is either incompatible with A1P1 either on its own or in conjunction with Article 14. We are content for this court to make either finding.
I don't see why we should at the moment. And speaking for myself, I'm well aware that there's a huge body of European case law on the ambit of A1P1. Tax cases, benefits cases, Steck indeed is the leading authority. But on the basis of obiter dicta, even by somebody as distinguished as Lord Justice Leggett, I think maybe just a little ambitious.
That may be so, my lady. We hope to persuade you that, as a matter of principle, if it is the case that a chosen action or a welfare benefit can fall within the ambit of A1P1, there is no particular good reason why the right to have a claim determined in court with a prospect of a pecuniary remedy should not also...
Well, it's more tenuous. because your claim to damages isn't a defined existing right, whereas your pension benefit is. That's the start for the distinction, and you then go down the slippery slope. I mean, I admire your ingenuity.
Was this all argued in front of the Supreme Court? Because you said that your assumption didn't go beyond Article 6. Was it all argued? Obviously, JT is a subsequent authority.
The A1P1 point was not argued.
Article 14 was argued.
The Article 14, I believe, was argued, but having already decided on the Article 6 point,
Assumption decided not to go
he
there.
decided not to decide that point. So he neither accepted nor refused it.
Is there any particular advantage to your client in going beyond Article 6, apart from the intellectual satisfaction of it,
My
in
lady,
practical terms?
in practical terms, a declaration is a declaration, and it of course falls to Parliament as to whether it chooses. So, in practical terms, the primary case is Article 6, and that of course suffices. We hope to get the claimant home.
I mean, you don't need Article 6, do you? Or do you? You do need Article 6 to succeed here, in one sense, because you would have got the declaration had the tribunal, you say, had the tribunal had the power to make it.
Yes.
That's right.
So that's why you're arguing this point. But 14 is really a belt and braces, isn't it? And it wasn't really. This hasn't. To what extent has this been canvassed? This whole argument been canvassed below? It hasn't, is it?
I don't believe, no, Article 14 hasn't been canvassed below, but we say that by and large it was. Sorry, I'm told Article 14 was in the EAT.
A1P1.
Was not. That's correct. Yeah.
It's quite difficult, A1P1. There is a lot of law in it. Isn't there?
Not all of it compatible, I should tell you. Different strains of authority at different levels. It's not an easy area. And we haven't got any of it in front of us.
We've just got Lord Justice Leggett, which is
That's right. My lord and my lady, there's nothing further that I can assist you on regarding the declaration. I would like to offer a few remarks on Article 47 of the Charter.
Yes.
Which, the text of which is set out at page 58 of the authorities bundle. I believe that my learned friend Mr. Jackson touched on this briefly, but it was the conclusion of the Supreme Court in Benkarbouche, and it has been uncontentious in these proceedings too, that while the scope of Article 14 is not identical to the scope of Article 6 of the Convention, if Article 6 is violated, then so Article 47 will also be violated. That, as I say, has been uncontentious. It was also the Supreme Court, the decision of the Supreme Court in Benkarbouche, paragraph 78, which is page 214 of the bundle. At the very bottom of page 214, Lord Sumption states that it follows that there is no separate issue as to Article 47 of the Charter. The only difference, of course, is one of remedy.
Yes.
Whereas, of course, the remedy for an inconsistency with Article 6 is the declaration that we've asked this court to make. on the other hand, where there is a conflict between the Charter and domestic law, for claims brought prior to the Withdrawal Act, it is the latter, domestic law, that must be disapplied. And insofar as the claimant requires this court to do so, we therefore ask, in addition to the declaration, that this court disapply section 4.2a. My lords and my lady, unless there are any further questions, I will hand back to Mr. Jackson to conclude the claimant's case.
Mr. Jackson, peroration.
A very, very short one. It may not be a helpful answer to my lady's question about practical benefits. There may be, I'm afraid, is the answer, in the sense that whilst there is no remedy other than the declaration domestically, because Article 13 of the Convention has not been incorporated, there may be some distinction because, unfortunately, the European Court is occasionally inconsistent about how it treats deprivation in respect of trials and things which are property. So there may, if there is to be a complaint to the European Court, be a difference potentially in what the just satisfaction might be. I can't offer the court any more reassurance than that because, unfortunately, the case law on just satisfaction in both the Grand Chamber and the chambers is not, unfortunately, does not speak with one voice. And the only other points to conclude with are, first of all, can I check? None of us have thus far said very much about the European Union Withdrawal Act. I'm not planning to now. I did just want to make sure that we've offered this court sufficient reassurance that we're not inviting you down a blind alley. If we have, then I hope that's sufficient. And secondly, if, as it appears, we might finish today rather than tomorrow, can I apologise? Because although the certificate says it came from my learned friend, it was me who suggested we might need a day and a half because of the length of time in the EAT and the possibility of the Secretary of State intervening. So if tomorrow eventually becomes dead time, that's my fault, not anybody else's.
None of us is ever going to complain about being given a bit of extra time.
So unless there's any other questions I can assist with or any other points, those are the claimant submissions.
Thank you very much.
My lords, I don't have anything to say in response. And simply on the in relation to the incompatibility issue, the Kingdom of Spain is neutral. That of the British government doesn't want to tread on its sovereignty.
Yes.
Very nicely put.
That's very clear note on which to end. Right, okay, thank you. We are grateful for your submissions, oral and written. We will reflect on them and give a decision in writing. As counsel know, but I have to repeat this in every case, two things about judgment which will be sent out. It will be a draft. That doesn't mean that it's being sent out for re-argument. It's only sent out for correction of typos and obvious factual errors. Second point is that, as per the judgment of this court in the Counsel General for Wales's case, the contents of the judgment are confidential to the parties until the formal hand down and publication on the National Archive. In this case, on the claimant's side, obviously that's Ms. Lorenzo and her lawyers. On the Kingdom of Spain's side, it's the lawyers and anybody in the embassy who needs to know in order for instructions to be given, but they're all bound by the same confidentiality obligation. Thank you all very much.
you end up finding the chicken?
No, I'm still looking for the chicken run, and